Hello, everybody. This is Dr. Cole. It is early Sunday evening, October 19th, and this is the Week 10 announcement for Political Science 3753 Constitutional Law, Fall 2025. All right, everybody. What we have on the syllabus this week is obtaining evidence, search and seizure, Fourth Amendment issues, as we continue to look at some material that may be very relevant to you if you're going to be working in the criminal justice system, as I know some of you are. Wednesday and Thursday we have, I believe it's discussion 5, and we have what I hope will be a very interesting article for you to look at, going back almost a decade from the Atlantic Monthly by reporter Emily Yaffe, I believe the name is, Innocence is Irrelevant. Now, we're taking a look here at how the criminal justice system works on a day-to-day basis. It has constitutional implications. Now, really, some of what is going on here may be more relevant to you if you are working in a big metropolitan area, as some of you will be, I measure. You may be, at least. As you read through that article, as you get toward the end, notice you will see the reporter sat in on a meeting between the prosecutor and 2 public defenders, and notice how they go through a series of cases in lickety-split fashion. So people's fates in these proceedings are determined in a matter of a few seconds. As you're aware, the consensus would be that the system could not stand all or even many of these cases going to trial. It would be a serious burden on the criminal justice system. So the vast majority of cases are resolved in a plea bargain, which an individual pleads guilty to a lesser charge very often would be the kind of thing that would happen. The thing is, constitutional issues are raised because you don't have a trial before a jury of your peers to try to vindicate your rights, and the implications can be serious, especially for poor people, as is so often the case in many of these proceedings. They end up bearing expenses that might not be all that crippling for you or me, but for someone living paycheck to paycheck who doesn't have much set aside to start with. Then on top of that, there's the matter of having a record of some kind, which could have serious implications, trying to get a job, of course, or some such thing. So it's worth thinking about that. It has turned out that this is the way our system works in the criminal justice system for so many people. So I hope you will take a close look at that, and we'll be discussing that this Wednesday and Thursday. Let's see now. That would be, I believe, the 22nd and 23rd. That's our 5th discussion, I believe. Remember, over 48 hours, post initially, and then post at least once in response to your classmates. One of your classmates, you may post more often than that if you wish, but please try to post at least twice, initially, and then in response to at least one of your classmates. Now then, everybody, what we have on the syllabus this week, again, search and seizure, the Fourth Amendment. Among the important precedents here, okay, the Stanford Daily case stipulated, and actually Congress came along in the wake of the case and stipulated that a media organization should be served with a subpoena rather than a search warrant. That way, with a subpoena instead of a warrant, the law enforcement people do not have to go rummaging through the offices of the media organization. Instead, the burden is on that organization to answer the subpoena and produce the material that's being asked for in the subpoena. So that is an important precedent. The Stanford Daily case going back to 1978. Now, everybody, what the Fourth Amendment says is that there are to be no unreasonable searches or seizures. Okay? And where a warrant is required, it must specifically name the items being searched for, which raises a question. When is a warrant necessary and when is it not? Okay. The language makes it sound as though a warrant is not always necessary. But if it is, if a warrant should be issued, okay, there are certain requirements that must be met. It must specifically name the items to be searched for. It's not a general warrant to go rummaging around without knowing exactly what it is you're looking for. Now, any number of exceptions to the warrant requirement have been carved out. Okay, we go through them one by one. Perhaps the most important is the exception for automobiles, because automobiles are movable. Okay, and if you cannot search the automobile, the people in the automobile may flee. So that is a very important exception to the warrant requirement. And cases of this nature continue to go through the system, and these requirements are further and further refined. Another important precedent is Terry versus Ohio in 1868. This is just before Chief Justice Earl Warren left the court. Now, he's regarded as a liberal and someone who very often is criticized by ideological conservatives. But this is one of Chief Justice Warren's more conservative decisions, because this allowed for stop and frisk procedures. Okay, in a case where an individual looks suspicious, you can do a limited stop or a stop and frisk. Okay, now it raises some constitutional eyebrows, but the court under Earl Warren allowed for that, and the precedent stands. So those are among the more important exceptions to the warrant requirement that are laid out here, and we go through them 1 through 8. Okay, so take a look at those. The most important ones are with regard to automobiles and the allowance of so-called stop and frisk procedures. All right, electronic eavesdropping, an interesting question. Okay, Olmstead versus United States, 1928, they said that a wiretap was not a search because you were not physically entering the premises that is being wiretapped. But the court, after about a 40-year hiatus, reviewed that issue and largely reversed itself in Katz versus United States, stipulating that the Fourth Amendment is there to protect people, not places. Now, many interesting issues come up in the wake of the War on Terror, the passage of the Patriot Act, the legislation that authorizes the Foreign Intelligence Surveillance Act. Some that is politically controversial and interesting, may not come up in your day-to-day work in the criminal justice system, but something that has raised eyebrows and received a fair amount of attention. Okay, the leeway they gave for searches in the wake of the War on Terror in the aftermath of 9/11/01. There was some effort to rein in those policies in the wake of the Edward Snowden revelations, which led to the passage of the USA Freedom Act. Something of a limitation on the authorities, but perhaps not all that much. You will look at the details of what was provided for in the USA Freedom Act 15 years after the original Patriot Act was passed. Carpenter versus U.S. 2018. Okay, this was a case in which they ruled that you could not use cell phone pings as evidence to pinpoint an individual's whereabouts, because they stipulated that cell phone use was becoming so widespread there ought to be some expectation of privacy in the use of a cell phone. So an individual was able to escape conviction because of that decision. Carpenter versus U.S. 2018, the kind of issue you can expect to be thrown in their laps with increasing frequency as time passes, with all the new technology that is impacting upon our lives with the passage of time. Now, something that will be important to you all in law enforcement, the exclusionary rule. Okay. The idea that illegally, improperly obtained evidence cannot be introduced. It took them a while to arrive at this doctrine. Okay. Eventually, they overturned the so-called silver platter doctrine. The idea that state and federal procedures were separate, and if evidence were obtained at one level of authority, it could be obtained at the other, okay, even if the procedures were not entirely proper. The silver platter doctrine, so-called. Okay, that was at issue in Weeks versus United States 1914, the federal exclusionary rule was applied, but not quite at that point to all levels of the judicial system. Okay. Wolf versus Colorado, 1949, they considered but stopped short at that time of applying the exclusionary rule to all levels of the criminal justice system. They go ahead and do that in Mapp versus Ohio, 1961. Okay, so something of a limitation that some people object to in gathering evidence for procedures in the criminal justice system. Note, however, a couple of decades later, a loophole or an exception to the exclusionary rule was carved out in the case of United States versus Leon, 1984, in which they now hold that the evidence can be introduced if the individual obtaining the evidence was acting in good faith, even if the warrant was defective. Some people see as a loophole big enough to drive a truck through. Okay, so they stopped short of the full exclusionary rule in Wolf v. Colorado, 1949. They go ahead and impose it in 1961 with Mapp versus Ohio, but then they create that exception to it, the good faith exception, in United States versus Leon, 1984. Okay, everybody, so be reading through those class notes and also that article for the discussion Wednesday and Thursday, which I hope will be of interest to you and eye-opening, and we will discuss that, okay, Wednesday and Thursday. Remember, please post at least twice to the discussion over the course of 48 hours, Wednesday and Thursday. Okay, that'll be it then for now. We move on next time to freedom of speech, and we'll have more quiz and discussions assignments for you. I believe that will be going out within the next week for quiz number 5, but we'll have discussion 5 this week. So search and seizure this week and discussion number 5. I hope you will take part, and we will talk to you again about a week from now at this time.